What's up, guys? Welcome to Lawsplaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small but feisty law firm in central Minnesota. And today, guys, I am not in the best mood because a giant idiot of a federal judge has issued a ridiculous order in the Cody Wilson Defense Distributed Second Amendment Foundation case brought about by, I think now, 22 attorneys general who are intent on trampling the Constitution and absolutely open about it. Let's talk about this. I'm going to start reading this case. I'm going to blaze through it, except when I stop and just rip it apart. So, bear with me. Kind of pissed off. Here we go. This matter comes before the court on the plaintiff state's motion for preliminary injunction. A temporary restraining order was entered on July 31st, 2018 by this judge who is now determining whether or not that order should keep going, basically. So where do you think this is going to go? Enjoining the federal defendants from implementing or enforcing a temporary modification of Category 1 of the United States munitions list. Let me point out right from the start that both the Code of Federal Regulation and the statutes that authorize how this United States munitions list is managed allow the government to do exactly what they did, and they both specifically say that this action is not reviewable by the courts. Both of them say it, and this judge, this giant idiot, has said, oh, I know Congress made a law that delegated authority to the executive branch and said, you know what, this is a political issue that is not really open for review by the courts, but I think the states might have a right to review it. What is he thinking? We're going to talk about that as we get there, because it blows the mind to think about what this judge has done. All right. The temporary modification of Category 1 of the United States munitions list in July 27, 2018 letter issued by the U.S. Department of State to Cody R. Wilson, Defense Distributed, and the Second Amendment Foundation. The order also required the federal defendants to preserve the status quo ex ante as if the modification had not occurred and the letter had not been issued. Basically telling the government, forcing the government to prosecute a case that they have decided not to prosecute. These attorneys general are trying to force the government to prosecute someone under a code that the government has decided they shouldn't be prosecuting people under. That's what they're asking to do. Think about this. State attorney generals are asking the federal government to go after a Texas citizen and Texas corporations out of their states for violations of a law that the government says is no longer being violated. They just soak that in. Soak in the ridiculous gall of these little mini tyrants and then kick them out. Impeach them. Get them gone. Get them gone from office. These people have to go. Build a wall around, I don't know, Iowa or Delaware or something, and throw all of the attorneys general in there and just leave them. Just leave them. All right. Pursuant to the limitations set forth in Federal Rule of Civil Procedure 65, the matter was set for hearing on August 10th. That's a timeliness rule, but the restraining order was extended by agreement of the parties to the 28th to accommodate an August 21st hearing date. Having considered the memoranda, no, you didn't. No, you didn't consider them, you liar. You're just lying. Because if you considered the memoranda, you'd see that there is no possible way that this ends up winning. This is a political move by a partisan hack. Period, period, period. Because under... Okay. Memoranda, declarations, and exhibits submitted by the parties, as well as the amicus curiae submissions of the Brady Campaign to Prevent Gun Violence, Every Town for Gun Safety, those two organizations can sunset themselves peacefully. And the Electronic Frontier Foundation the only respectable organization among the three, and having heard the arguments of counsel, the court finds as follows. Preliminary injunction standard. The standard for issuing a preliminary injunction is identical to the standard the court used when granting the temporary restraining order in this case, except if you go ahead and... Never mind. Never mind. Thus, for purposes of the current motion, the court considers the more developed record to determine whether plaintiffs, 1, are likely to succeed on the merits of their APA claim. There are statutes and regulations that specifically say that the APA does not apply to the decisions that were made here. Period. But they're likely to succeed. It's fine. Are likely to suffer irreparable harm in the absence of preliminary relief. Nope. Not a chance. Does any state suffer harm by demanding that the government enforce a regulation about foreign transmission of this data? Because even as the judge concedes, if they just printed this stuff on CDs and handed it to people, or as this ridiculous idiot of a judge suggests, they could even email it, they just can't post it. Even though everything that happens with posting and downloading can effectively happen via email. So if they just email it or hand it out, it's perfectly fine. Yet somehow the states would be harmed by their posting this on their own website, which is a big website amongst enthusiasts, right? But literally, if they printed off 1 billion CDs and walked into New Jersey and handed one to every single person on the side of the road, perfectly fine. How is New Jersey then protected because they're not doing this physically? They could honestly get a mailing list. They could go and they could mail these CDs out. And if you don't know, you can go to the post office and get a guaranteed mailing to every single household in the postal delivery service. In theory, they could do this and mail every American a CD with these files on it. Every single person, household, and apartment they could mail this to. They could mail a big stack of them to hotels so they can put one on every bed. All they have to do is do it. And that would be legal. But a judge has decided that them posting it online at a website that would reach far fewer people than that method is somehow going to hurt the states. Nonsense. Stupid. Stupid judge. You coward. All right. Have shown that the balance of equities tips in their favor. No. And have shown that an injunction is in the public interest. They're saying an injunction against speech is in the public interest because this injunction protects the rights, theoretically, of states' attorney generals, not of the citizens of that state. The nonsensical mental gymnastics here. I don't even know how to describe them. In the alternative, if a plaintiff can only show that there are serious questions going to merits, a lesser showing than likelihood of success on the merits, then a preliminary injunction may still issue if the balance of hardships tips sharply in the plaintiff's favor, this is the reduced standard that they used for the preliminary or for the temporary restraining order. And it's basically how they're going to get there today because there's no way they fulfill the 4-part test listed above. Not a chance. And the other 2 winter factors are satisfied. Okay. So here are the footnotes. The request for leave to file amicus curiae briefs are granted. So that's the 3 foundations mentioned above. You have to request permission from the court to file if you're not a party. The court grants them and then considered their amicus curiae. Footnote 3, the court finds that the injunction plaintiffs seek is prohibitory in nature rather than mandatory. A prohibitory injunction maintains the status quo, which is generally described as the last uncontested status which preceded the present controversy. In this case, the status quo existed before the federal defendants issued the temporary modification letter on July 27th. Even though that's not actually the status quo. Because that wasn't an unchallenged status. It was literally in challenge. How could it be the last unchallenged status, you dumb judge? The last unchallenged status would have been in 2012 when Defense Distributed published the files, not in violation of ITAR, and then they were found to be in violation of ITAR later and then challenged. You liar. You liar. Okay. Since at least 2013, the federal government had taken the position that the Arms Export Control Act, 22 U.S.C. 2778, which authorizes what they did here in Section H, authorizes restrictions on the internet publication of computer-aided design data files that would allow the creation of guns and their components with a 3D printer. When Defense Distributed posted CAD files for various weapons on its website at the end of 2012, the Directorate of Defense Trade Controls, which is part of the Department of State, notified Defense Distributed that the publication may have been unauthorized and in violation of the AECA's implementing regulations, the International Traffic in Arms Regulations, or ITAR, which is 22 CFR 120 to 130. The DDTC explained that the making of CAD files available on the internet constituted a disclosure or transfer of technical data to foreign persons and was considered an export subject to the AECA and ITAR. The government advised Defense Distributed to remove files from its website and, if it believed the files were not properly subject to export control, to utilize the commodity jurisdiction procedure to obtain an official determination from the DDTC. Defense Distributed filed a number of determination requests when the DDTC failed to make timely rulings. So what's their relief? What's their relief when the government fails to make timely rulings under their own law? Too bad. Harmless error that it's untimely, right? That's how this works. Defense Distributed filed a lawsuit in the U.S. District Court for the Western District of Texas. That litigation pitted Defense Distributed and the Second Amendment Foundation on one side against the Department of State, the DDTC, and various federal employees on the other. Defense Distributed challenged the federal government's power to regulate its publication of the CAD files on the internet, arguing that the regulation subjected its gun-related speech to a system of prior restraints that was applied in an arbitrary manner in violation of Defense Distributed's First, Second, and Fifth Amendment rights. And they're absolutely right. They're absolutely right. A month after the Texas litigation was filed, the DDTC determined that some, but not all, of the CAD files Defense Distributed wanted to publish on the internet were technical data subject to the ITAR. Defense Distributed filed a motion for a preliminary injunction in the Texas litigation to preclude the federal government from imposing pre-publication approval requirements on any of its CAD files. Federal government opposed the motion, arguing that, and these arguments are important only because the judge has determined that because the federal government made these arguments in 2013, that they couldn't possibly have changed their mind in the ensuing 5 years and administration change. They couldn't possibly have done that without coming up with some set of data. And they also erroneously rely on the fact that this was these decisions and these arguments were based on actual data rather than nonsense. Because I'll tell you what they're based on. Nonsense. But here we go. Here's their arguments. Export of Defense Distributed's CAD files could cause serious harm to U.S. national security and foreign policy interests that warrant subjecting the files to ITAR's export licensing of technical data. Notice that even though these files have been available on the internet for 6 years, and 3D printing has been available for 6 years or longer, not one incident has been reported. Not one incident has used one of these 3D printed guns that has caused danger to the United States in the way that these people all say it will. Not once. To my knowledge, not one assault, murder, rape, illegal discharge, not one has happened in 6 years that this stuff is findable. People have this all over. You can do these. You can make your own. You don't even need Cody Wilson's files to do this. Other people have done the same thing. Not even once has it happened. Defense Distributed's CAD files constitute the functional equivalent of defense articles, capable, in the hands of anyone who possesses commercially available 3D printing equipment, of automatically generating a lethal firearm that can be easily modified to be virtually undetectable in metal detectors and other security equipment. But not the bullets that it has to fire, and not the firing pin that's required to fire it. So yes, in theory, you could make the gun undetectable and smuggle it on a plane, except you can't use it without metal. It doesn't work without a metal firing pin and metal bullets. It's non-functional without the metal components that are detectable. So this is absolutely untrue. The State Department is particularly concerned that Defense Distributed's proposed export of undetectable firearms technology could be used in an assassination for the manufacture of spare parts by embargoed nations, terrorist groups, or guerrilla groups. Because it's so much easier to spend thousands of dollars making an undetectable gun than it is for them to just bring a gun and shoot someone. Which assassinations occur with swords, guns, anything anyone can get their hands on. Mostly, it's just opportunity and will that get them done. It's not a 3D printable gun that's not detectable, because you still need the bullets. You still need the bullets. Or to compromise aviation security overseas in a manner specifically directed at U.S. persons. Because I guess they could bludgeon someone with the 3D printed gun that can't fire plastic bullets. Both the government, so the next argument, both the government and the public, quote, have a strong interest in curbing violent regional conflicts elsewhere in the world. Why? Why does the United States government, and more importantly, the public, have any interest in curbing violent regional conflicts elsewhere in the world? That's not true. We might have a minor interest, but a strong interest? I don't think so. That does not sound like any interest enshrined in the United States Constitution to me. But who am I? Especially when such conflict implicates the security of the United States and the world as a whole. The 3D printed gun implicates the whole world. You know, Russia is delivering, ostensibly, like this is the claim, right? That they're providing sarin gas missiles to the Syrian regime and stuff like that. The United States, Lockheed, our very own Lockheed Martin provided bombs that were used by the Saudi government to blow up a bus full of civilians, but it's this 3D printed gun. That's the real risk, right? Right? God. The lies. The lies. The then director of the Office of Defense Trade Controls Management, Lisa V. Aguirre, concluded that the unrestricted export of defense distributed CAD files would result in the production of plastic firearms that are fully operable, because she's an idiot. Because she's a giant idiot. You can't create a fully operable plastic firearm. They still have metal. And virtually undetectable, which means that they're actually detectable by conventional security measures. 5-year-old conventional security measures from 2013. Not counting today, not counting the new security measures. All those things in airports that scan you and the backscatter imaging that can detect things that aren't metal. That stupid thing you got to stand there and do. That they used to make fun of because it measured people's genitals, right? Like that they would always ask, make sure Fergie got in there, right? 'Cause, for no reason, though. That they're used to commit terrorism, piracy, because pirates need undetectable weapons on their own ships when they storm other vessels and take them over with AK-47s. But a 3D printed gun is going to stop the piracy, or is going to be a real boon to those pirates, right? Assassinations or other serious crimes would cause serious and long-lasting harm to the foreign policy and national security interests of the United States. That efforts to restrict the availability of defense articles to enemies of the United States would fail. You give them This is the administration that just gave guns to cartels in Mexico. And every administration, going back to Reagan, Kennedy, Nixon, before, all the way back to FDR, we have sold weapons to hostile regimes for decades. Bigger weapons than this, certainly more dangerous weapons than any of these things. Okay, that the proliferation of weapons and related technologies would contribute to a more dangerous international environment, and that the export would undercut the domestic laws of nations that have more restrictive firearm controls than the United States' foreign relations with those nations would suffer. How? How would that suffer at all? The Honorable Robert L. Pittman denied the motion for preliminary injunction, noting that Defense Distributed's avowed purpose is to facilitate, because their mission statement is that they want everybody on the globe to have access. They then took that mission statement and said that they're trying to send this stuff to hostile regimes. Basically, that's the extrapolated argument of the honorable and honest Ronald L. Pittman. Global access to and the collaborative production of information and knowledge related to the 3D printing of arms, and that such activities undoubtedly increase the possibility of outbreak or escalation of conflict. Zero incidents. Zero incidents. And are of the type Congress authorized the president to regulate through the AECA. See, now they care about that regulation authorization by Congress, but in a minute they're not going to care about it. The Fifth Circuit affirmed, finding that the State Department's stated interest in preventing foreign nationals, including all manner of enemies of this country, from obtaining technical data on how to produce weapons and weapon parts, constitutes a very strong public interest in national defense and national security. In April of 2018, the federal government moved to dismiss Defense Distributed's lawsuit, reiterating that what was at stake was the United States' ability to control the export of weapons, a system of laws and regulations that seeks to ensure that articles useful for warfare or terrorism are not shipped from the U.S. to other countries, except bombs to Saudi Arabia, or otherwise provided to foreigners, without authorization. See, it's the government that can do it. Where, beyond the reach of U.S. law, they could be used to threaten U.S. national security, U.S. foreign policy interests, like by bombing a bus in Saudi Arabia, or international peace and stability. Later that month, the parties reached a tentative settlement agreement. Wait, what's this? The parties had taken extreme positions at the beginning of legislation, and then over 5 years of discussion and argument, decided to back off of those positions and reach settlement, like what happens in something around 99% of civil litigation. Only almost every case works out this way, but this judge is going to act like he has no idea how this could possibly happen. Honestly, that's what's going to happen. This judge who sees this probably 12 times or more a day is going to somehow be bewildered at the process. That's how willfully stupid these people are being. Pursuant to the settlement, the Department of State changed course, abandoning its prior regulatory and litigation positions and allowing the private defendants, Defense Distributed, the Second Amendment Foundation, and Williamson to publish on the internet CAD files for the automated production of 3D printed weapons. Yeah, they changed their mind over 5 years of litigation. The federal government specifically agreed, among other things, to publish a notice of proposed rulemaking, and final rule, revising the United States munition list to now allow the distribution of the CAD files, to announce a temporary modification of the USML, which is authorized in the Federal Register of Regulation, to allow immediate distribution while the final rule was in development, and to issue a letter to Defense Distributed and other defendants advising that the CAD files are approved for public release and unlimited distribution, because the government has decided not to prosecute under the existing rule. Just like the Obama administration decided not to prosecute people in sanctuary cities. Just like the Obama administration decided not to prosecute people in Colorado in violation of the Controlled Substances Act when Colorado legalized weed. They can make the determinations for enforcement. That is a power of the executive branch to execute its delegated authority in a manner that it finds reasonable, and it's been upheld by federal courts ridiculous amounts of times with stunning clarity that the federal government has discretion to enact the delegated tasks from Congress pretty much the way it wants to, including non-enforcement. Let's keep going. The federal defendants also acknowledged and agreed that the temporary modification and letter, quote, permits any U.S. person to access, discuss, use, reproduce, or otherwise benefit from the CAD files. The announcement of the temporary modification and the issuance of the letter were to occur on or before July 27th. No findings of fact or other statements are provided in the agreement that could explain the federal government's dramatic change of position or that address, much less invalidate, its prior analysis regarding the likely impacts of publication on the United States national security interests. Mind you, they don't have to do this. The State Department does not need to publish its reasoning for changing its mind. They have delegated, Congress has delegated the full authority to the executive, specifically to the State Department, to do this. They don't have a check. There's no congressional veto on this power, and there is no judicial review of it. It's in the statute. So they don't have to publish this. The judge just is deciding that they should, even though they don't have to. On May 24th, 2018, the federal defendants published the promised rulemaking notice with the public comment period ending on July 9th. The settlement, which is over 30 days. The settlement agreement was signed on June 29th in the midst of the public comment period, but not made public until July 10th, 2018. The temporary modification was published, and the letter to private defendants was issued on July 27th. 3 days after the temporary modification was published, 8 states in the District of Columbia filed this lawsuit, alleging that the federal defendants' conduct was ultra vires and in violation of the Administrative Procedure Act and the 10th Amendment to the United States Constitution, except these powers aren't reserved to the states because they're specifically enumerated to the executive and legislative branches of the federal government. So it's not a 10th Amendment violation. You're lying. And you know it because you're state's attorneys general, so you have to know that you're wrong. You have to know. This isn't a matter of disagreement, by the way. These are specifically enumerated authorities in the federal government to provide for the common defense, to manage foreign relations. They're in the Constitution, and they're not reserved to the states. They're specifically disreserved from the states. They're why the federal government actually exists. It's specifically not a 10th Amendment a 10th Amendment issue. So, footnote 4, an amended complaint adding 11 more states, commonwealths as plaintiffs was filed on August 2nd. So yes, now we're up to, what? It was 8 plus 1. Now we have 20. After an expedited hearing, the court found that plaintiffs had shown a likelihood of success on the merits of their Administrative Procedure Act claim because he just lied to himself, insofar as the temporary modification resulted in the removal of one or more items from the USML. Except those items weren't removed from the USML. They basically just said, we're not going to enforce while we pursue the rule change that we have plenary authority to enact. Plenary authority means unchallengeable authority. They can do this rule change and the judiciary can't do anything about it. They're trying to create a rule change that happens before the rule change and saying that that's wrong. And if they win, the second rule change can still occur and invalidate this whole thing. This is just a waste of time and resources. It's politicking and it's bleeding a citizen dry of money and it's disgusting. Plaintiffs had shown a likelihood of irreparable injury if an injunction did not issue, because Defense Distributed had announced its intent to make the CAD files downloadable from its website on August 1st, and that the balance of hardships and the public interest tipped sharply in plaintiffs' favor, even though 0 incidences of violence involving 3D printed stuff. As far as I know, correct me if I'm wrong. Please, please do. I can be wrong. I've never heard of it. Never heard of it. Plaintiff's request for a preliminary injunction is centered on its claim that the federal defendants violated the APA. The APA authorizes judicial review of final agency action and provides that reviewing court shall hold unlawful and set aside agency action findings and conclusions found to be arbitrary, capricious, and abuse of discretion or otherwise not in accordance with law. There's a statute and a regulation authorizing this in excess of statutory jurisdiction, authority, or limitations, or without observance of procedure required by law. Plaintiffs argue that the federal government's efforts to immediately remove items from the USML through issuance of a temporary modification which is in the law as something they can do, and is not a removal of the items. It is a temporary modification. There's the entire possibility that they attempt to do the rulemaking and they can't get it done for whatever reason. Maybe SecDef doesn't sign off on it as required by the statute. There are all sorts of ways that the rule can fail, and if that happens, then their temporary modification becomes obsolete. It's gone. It goes away because it was temporary. This is a temporary modification, not a rule change. And the judge can't just make it a rule change. I mean, he can. He can by lying. Judges can do this. And this is the problem with how federal judges have been acting lately. They can make something up knowing it will be overturned on appeal. This will not survive. Just like the travel ban was definitely within presidential authority, but some Johnny Cuck out in the middle of nowhere in the Ninth Circuit just decides that he can stop the president even though the president has the authority to do it. And lo and behold, the Supreme Court took about 10 seconds to decide whether or not the president had the power. Wait, Congress said he has the power, and he's the president, and this is a matter of foreign relations? Absolutely, the president has the power. What was anybody thinking? But remember, a Ninth Circuit judge said they were likely to succeed on the merits, just like here, when they're obviously not. Okay. Temporary modifications were procedurally defective in that the State Department failed to give 30 days notice to the Congressional Foreign Relations Committees specified in 22 U.S.C. 2778 F1. Notice they ignore Section H, which says that they don't need to do this, but you know, and failed to obtain the concurrence of the Secretary of Defense as required by the President when he delegated his removal authority to the Secretary of State in Executive Order 13637. Even though, as the judge will state, it doesn't matter that SecDef doesn't sign off, because in that executive order it says that it doesn't create any legal responsibility. So, you know, they can just go ahead and ignore that anyway. Oh, let's read this footnote. Plaintiffs, citing a presidential tweet and a White House press briefing, also suggest that the State Department exceeded its authority over the USML because the president disagrees with the way in which that authority was exercised, which is actually a misread of that tweet, but you know, go ahead. Plaintiffs acknowledge, however, that the president has delegated USML designations to the State Department. That's because he did. That delegation was not conditioned on obtaining the president's prior approval, because an executive veto doesn't work that way, or of subsequent acquiescence to a listing decision. To the extent the president believes that allowing printable guns to be published on the internet is not sensible, he has the power to influence, if not outright direct, the State Department's decision-making in this matter. He has not yet done so. No. That's not necessarily true. You don't know what he has done for the State Department, because remember, the State Department changed tune after Trump was in office. This tweet doesn't obviate any other discussions that have happened. Also, none of you believe Trump on Twitter anyway. All right, back here. Plaintiffs also argue that to the extent the temporary modification permits any United States person to use the CAD file at issue, federal government's action impermissibly conflicts with state and federal laws limiting access to guns. No, it doesn't. No, it doesn't. because doing this is not a violation of state law. It's absolutely not. And they're misreading that letter on purpose. They're being pedants, we'll say. Finally, plaintiffs challenged the decision to allow the CAD files to be published on the internet as arbitrary and capricious because the State Department failed to articulate any explanation for its decision to allow the publication of the CAD files on the internet or to alter its earlier factual findings and representations regarding the harm such publication will likely cause. Except they don't have to do that unless they're restricting freedom, not when they're enabling more liberty. When they're restraining government and not restraining citizens, they don't have to have a non-arbitrary and capricious reason. And you can't state that their reasoning is arbitrary and capricious just because they haven't disclosed to you the methods that they used. They don't matter. They don't need to do it. It's not in the statute. Both the federal and private defendants challenged the court's jurisdiction over this matter. Federal defendants argue that the states lack standing. They do. While the private defendants argue this lawsuit is an impermissible collateral attack on the outcome of the litigation in the Western District of Texas. Which is true. It is true. They should have brought this in the district in the action that was occurring. They could have filed for an interpleader and gotten permission from the court to make the case on their own behalf that this was wrong. But they didn't. They forum shopped to the Ninth Circuit where they knew they'd find a favorable opinion. And if you think they did anything other than that, know that they filed this in other districts and were turned down. But they went to the Ninth. And they knew they would get it there. In order to present a justiciable case or controversy under Article 3 of the U.S. Constitution, plaintiffs must have standing to challenge defendants' conduct and pursue the relief requested. I'm not going to read the long block quotes here. In an APA action, a state alleging a procedural violation has standing if there is a possibility that the relief requested will prompt the agency to reconsider the decision that is allegedly causing harm. No, it won't. No, it won't. Because they're proposing a massive rule change and a temporary statement saying that, you know what, we're not going to enforce the rule while we're going after the rule change. They're not going to change their minds just because the states don't want them to succeed on a temporary rule change. Why would they why would they undo a permanent rule change because the state succeeds in enjoining them on a temporary one? It doesn't make any sense. Because ultimately, at the end of the day, let's say the states win everything. The next day, the State Department can file the rule change with Congress and get the Secretary of Defense's signature on it, and 30 days later, the rule change happens, and all of this is for nothing. Because that's the ultimate result. That's the ultimate outcome, is that the states can all go win, and then the next day lose. Because the federal government just wants to do it this way. So it doesn't make sense. It doesn't make sense. In addition, a state has a legally protectable interest if it has a sovereign, quasi-sovereign, or proprietary interest that would be impacted by litigation. They don't. They don't have a sovereign, quasi-sovereign, or proprietary interest in what happens with the export of weapons data. That's entirely within the purview of the federal government, zero purview of the states. Plaintiffs allege that the federal defendants failed to provide notice of their intent to remove technical data related to the manufacture of 3D guns from the USML and have made a wholly unsupported and therefore arbitrary and capricious decision in which, in the State Department's own words, will make anyone in possession of a commercially available 3D printer, so a bunch of nerds, capable of automatically generating a lethal firearm, which is not true. It's not automatic. It makes a bunch of little parts and you have to put them together. And it doesn't make them perfectly because the resolution on 3D printers isn't perfect. That would be virtually undetectable in metal detectors, which is a lie. It's an absolute lie because the firing pin is still metal and the bullets are metal and other security equipment. Federal defendants assert that these are federal, these are attorneys general of states lying under oath in making their complaint. They know this is not true. They have to know. Either that or they're just seriously simpletons that are not mentally capable of doing their job. The federal defendants assert, like, oh, I would love for you to prosecute me, like if I had one of these and you tried to prosecute me, I would rake you over the coals. We'd have a 1983 claim for you trying to enforce laws against me that I'm not violating. It would be a bloodbath. It would be an absolute bloodbath if they went after someone based on what they're saying here. They know they're lying. The federal defendants assert that the alleged failures are harmless or are causally unrelated to any harm the states might suffer because the federal government's regulatory authority under the AECA is limited to exports and the plaintiff's concerns are purely domestic. That is absolutely right. And the next line from this judge, he deserves a fist in the face. Honestly. Defendant's argument is so myopic and so restrictive as to be unreasonable. No, it isn't. No, it isn't. This is about jurisdiction, buddy, and they're arguing about things that aren't related to this case at all. The federal government has no authority over what the states do about these issues. Notice these states don't have laws against 3D printed firearms. You know why they don't? 'Cause they'd lose. They'd lose. Federal government controls the export of the data, and if the states tried to restrict the export of the data, they would lose. They don't have standing. And if they tried to prevent Cody Wilson from publishing it in a lawsuit, they would lose because this is protected speech. Okay. Here we go. Whatever defendant's statutory authority, not whatever, it's the core issue in this case. The fact that the internet is both domestic. The fact is that the internet is both domestic and international. Ask China if that's true, you dummy. The federal defendant's determination that the 3D files at issue are subject to regulation under ITAR and could not, therefore, be published on the internet reduced risk of the proliferation of untraceable and undetectable weapons, assassination, aviation, and other security breaches. No, no, no. We have no evidence that it reduced that risk. We have zero evidence that the risk would be increased or was reduced. We have no evidence on this because there have been zero incidents and violations of gun control laws both abroad and at home. Nope. 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 The at home doesn't matter because this is about exports. You know, just keep focused, Judge. Thus, the alleged failures to provide notice and make a reasonable evaluation of the risks and benefits of the proposed action that they discussed for 5 straight years of litigation. But they didn't consider it, though. Of the proposed action not only impact national security, but have domestic repercussions. Domestic repercussions of strictly federal international issues have long been held to be subservient to the enumerated authority of the federal government. Do you guys know that the federal government can stop you from suing other states or other nations? Like the federal government can say, you know what? Sorry, we know you really want to sue like Saudi Arabia for its role in 9/11 because you can produce evidence that suggests that Saudi Arabia had a direct hand in 9/11. I think because like nine of the hijackers were Saudi or whatever. Like, let's say you could do that. Let's say you could produce that evidence and you went to sue Saudi Arabia. Federal government could say, oh, sorry, we have authority over foreign relations and you can't sue that foreign state because it'll harm our foreign relations. Domestic issues are below domestic concerns of states, and sometimes their citizens are below the authority of the United States government in foreign relations. You know, only all of the case law suggests this. Okay. The court finds that the plaintiffs have not only alleged harm to their legally protectable sovereign interests under the traditional standing analysis, but have also alleged a procedural APA claim where there is a possibility that compelling compliance with the specific procedures will prompt the agency to reconsider its decision. That doesn't make sense. Forcing the federal defendants to give Congress 30 days notice of the removal of the CAD files from the USML and to seek the concurrence of the Department of Defense would afford other executive branch entities, including the president, who have had 5 years to weigh in on this, an opportunity to impact the decision-making process. The president, which undoubtedly, through his appointment of Jeff Sessions, through the people who are arguing this case, who are arguing the case right now, the president who has undoubtedly impacted the decision-making process towards the benefit of the defendants, and would give both Congress and the states a chance to generate any statutes. The states have had 5 years to generate these statutes. And the state, if no state is generating a statute in a 30-day comment period, you disingenuous pile of garbage. Or regulations deemed necessary to address the regulatory void the delisting would create. Forcing the federal defendants to evaluate the effect of the proposed delisting on world peace, national security, and the foreign policy of the United States, factors which Congress intended the president and or his designee to consider. His designee is the State Department, who did consider it for 5 years and testified in front of you that they've considered it for 5 years. You disingenuous prick. May also prompt a reconsideration of the decision to remove the CAD files from the USML. There is, at the very least, a possibility that the states would benefit from relief of the requested in this legislation. First of all, I'll strongly disagree that there's even a possibility. And second of all, a possibility isn't sufficient. They have to be likely to succeed on the merits, not have a possibility. Plaintiffs have standing to pursue the relief requested in the amended complaint. Plaintiffs have alleged an injury in fact that is directly threatened by the federal defendant's proposed delisting of the technical data contained in defense distributed CAD files. But the states don't, I can't stress enough, the states do not have the authority to stop the State Department from delisting it. The only thing the states can challenge here is the lack of a 30-day thing on the temporary removal. They can't stop the permanent rule change. They can't. They don't have the authority or standing to do so. That's the smoke and mirrors here, is that they can't stop the ultimate change. They're trying to only stop the temporary change. Okay. And that could be ameliorated, if not avoided entirely. It certainly can't be avoided entirely, and it probably can't even be ameliorated, you liar. So here's the collateral attack argument. This is from Cody Wilson in Defense Distributed. The private defendants argue that this lawsuit is an impermissible collateral attack on the dismissal with prejudice of the Western District of Texas litigation. And it is. They reason that, had the states moved to intervene in the prior litigation in order to object to the proposed settlement or seek preliminary injunction precluding its execution, the motion would have been denied, and the states therefore cannot obtain such relief here. This is true. The conclusion does not follow from the premise. Yeah, it absolutely does. It absolutely does. The reasons the states would likely have not been permitted to intervene in the prior litigation is that they were not necessary parties. Because they lack standing, is what you mean. That's why they're not a necessary party. Otherwise, they could petition and be found to be necessary parties. But they lack standing. Even though you just said they have standing, you lied. They don't have standing. They had no right to appear simply because they were interested in its outcome. Absolutely true. Their claim had nothing to do with the facts or law at issue between the existing parties, and it still doesn't. And their APA-based objections could be heard and their interests protected in a separate litigation with the federal defendants. But no, if they had APA-based objections that were legitimate, they could have filed a motion and intervened in the other case. They probably still could, but they'd be denied because they don't have standing, because it's not the Ninth Circuit, and because that judge would probably say, no, these idiots don't have any say in my court. Get out. Get out. The district court's likely refusal to allow plaintiffs to appear and or intervene in the Western District of Texas litigation is not relevant to, much less dispositive of, plaintiffs' right to seek relief in this litigation. It is absolutely relevant, you liar. It's not dispositive, because I guess you can just decide they have standing, but it's certainly relevant that the other district would not allow them to comment on the case. If, as plaintiffs allege, the federal defendants exceeded their authority in entering into the settlement agreement with the private defendants, but they didn't, they are entitled to file suit under the APA, even though they're not, because under statute and federal regulation, they're not entitled to judicial review of this decision. Period. It's a delegated authority to the executive. This is a political question and would be thrown out by the Supreme Court. And seek appropriate redress. If the remedy afforded in this litigation impinges on the federal defendants' ability to perform under their settlement agreement with the private defendants, the latter may have a breach of contract claim against the former. You're going to create a breach of contract claim where there isn't one, but there is no jurisdictional bar to this litigation in the circumstances presented here. I think there might be. The dismissal of the Texas litigation is not under attack. Yes, it is. It's absolutely under attack. Because they're demanding that it proceeds as if it was still going. That's part of the ruling they're seeking. It's absolutely under attack. It has to go back. They're throwing it over the wall. Rather, the states are challenging the adequacy of agency action. Defendants offer no case law suggesting that violations of the APA can be shielded from judicial review by simply incorporating them into a private settlement agreement. They don't have to. They have statutory authority to do it. So this is about the likelihood of success on the merit. Congressional notice. The AECA authorizes the President of the United States to control the imports and the export of defense articles and defense services in furtherance of world peace and the security and foreign policy of the United States. The President has the power to designate defense articles and defense services. The items so designated constitute the USML. The USML identifies categories of defense articles and services that are subject to export control. The list is organized by paragraphs and subparagraphs that usually start by enumerating or otherwise describing end items, followed by major systems and equipment, parts, components, accessories, and attachments, and technical data and defense services directly related to the defense articles of that USML category. The USML Category 1 includes all firearms up to .50 caliber and all technical data, quote, required for the design, development, production, manufacture, assembly, operation, repair, testing, maintenance, or modification of such firearms. Through the CJ process, the Department of State specifically determined that the CAD files Defense Distributed seeks to publish are subject to the export controls of ITAR. The department, quote, may not remove any item from the munitions list until 30 days after the date on which it has provided notice of the proposed removal to the Committee on International Relations of the House of Representatives and to the Committee on Foreign Relations of the Senate, which they haven't done it. They haven't actually removed them from the list yet. Plaintiffs have shown a likelihood of success on the merits of their APA claim because a temporary modification of the USML to allow immediate publication of the previously regulated CAD files constitutes the removal of one or more items from the USML without the required congressional notice. No, it doesn't, you disingenuous liar. You know it doesn't. It's a temporary modification, not a removal from the list. They're still on the list until the rule change occurs. So no, it is not. You're making it up. The federal government represents that its settlement with the private defendants was a result of a multi-year review process in which the Departments of Defense, Commerce, and State determined that firearms up to .50 caliber would not provide a military advantage to adversaries and therefore no longer warrant export control and should be removed from the USML. Footnote 7. Federal defendants refused to produce the administrative record of the agency's decision and instead rely on the declaration of the Director of the Office of Defense Trade Control Policy within the DDTC. So they're just relying on the sworn affidavit under oath of an officer of the United States who specifically authorized to state this. He stated that they did this, and the court's not satisfied with that under oath statement that this was done in this way. Instead, the court wants some sort of administrative record of it to explain how and why the decision was made to reverse the CJ determination regarding the CAD files at issue. This tactic has placed plaintiffs in the court at a decided disadvantage. Nope, they don't have any place in determining whether or not this was done. This is done under the authority delegated to them by Congress and the President. in evaluating what the government relied on when concluding that the State Department's prior findings regarding the national security risk posed by plastic, untraceable, undetectable guns should be overruled. They don't owe you nothing. They don't owe you a thing. For purposes of the procedural APA claim, however, the declaration confirms that notice to Congress will be given as required by 22 U.S.C. 2778F if and only if a final rule is issued. So they're going to follow it. They just have a temporary rule in place until then, a temporary modification, which is in the statute and immune to judicial review. Judge is going to ignore that. Assuming that is the case, the federal defendants acknowledge that the governing statute requires that the results of the review be reported to Congress and precludes the removal of any item from the USML until 30 days after such notice is given. Yes, because they haven't removed them yet. The Department of State argues that its decision to allow the publication of previously regulated CAD files does not trigger the congressional notice requirement because it has not removed an item from the USML. It hasn't. Defendants argue that the notice requirement applies only when a whole group or category of defense articles described in the USML, such as non-automatic and semi-automatic firearms to caliber 50 inclusive, is removed, and that has not yet happened. This argument conflates category with item. No, it doesn't. No, you're conflating. Right? You're conflating a temporary modification authorized under the statute and the Federal Register. You're conflating that with a removal. It's not a removal until they remove it. As described in the statute, USML is a list of items designated by the President as defense articles and defense services, rather than generate an exhaustive list of every individual article or service that is subject to the export control under the AECA. Department of State opted to populate the USML with generally descriptive categories. Those categories describe end items, however, and it is those items that are defense articles and defense services that are subject to export control under AECA. See also fact sheet from the Obama administration. If that doesn't tell you everything you need to know, that the judge is relying on fact sheets from the Obama administration in making its decision, I've got news for you. I've got news for you. The congressional review and notice requirements specifically apply to items, not categories of items. But no items have been removed. You made up the idea that they removed. You invented that out of nothing. You pulled that right out of the magic hat between your cheeks, buddy. The department's CJ regulation further confirms that it is a removal of a particular article or service, i.e. an item rather than a category, that triggers the review and notice requirements. The department describes the CJ procedure as a means of resolving doubts as to whether an article or service is covered by the U.S. munitions list and to seek redesignation of an article or service currently covered by the U.S. munitions list. Immediately after the reference to redesignation, the regulations reiterate that the department must provide notice to Congress at least 30 days before any item is removed from the U.S. munitions list. Given the language, structure, and purpose of the statute and implementing regulations, except for the parts that you just ignore, the court finds the plaintiffs are likely to prevail on their argument that the terms item and category are distinct. It's not that they're not distinct, it's that the items haven't been removed, and that congressional notice is required whenever a previously designated defense article or service is to be removed from the AECA's reach. As noted above, the DDTC made an express determination that certain CAD files that can be used with a 3D printer to manufacture guns and or their components are defense articles or defense services under the USML. Defendants attempted to revoke that designation through the issuance of a temporary modification described in the settlement agreement in the Western District of Texas litigation. Guys, I can't state enough that in the exact same statute, it authorizes them to make a temporary modification without judicial review and without the 30-day review process. It's in the law that this judge has cited about 20 times. I can't stress that enough. That when he puts temporary modification in quotes, it's because that's a specific provision of a specific statute that authorizes them to do specifically this thing. Described in the settlement agreement in the Western District of Texas litigation, thereby removing the CAD files from the USML, not true, and lifting all export controls. No, temporarily modifying the export controls. The court rejects the private defendant's attempt to distinguish the term remove and exclude in this context. Because they're not removing them from the list, they're excluding the enforcement. You know, Congress was not notified prior to the removal. They don't have to be for a temporary modification. This procedural failure cannot be rectified by providing congressional notice 30 days in advance of any final rule removing firearms up to 50 caliber from the USML. The temporary modification was an effort to implement the removal immediately. Not, you've made that up. You've decided that that's what it was, without waiting for the rule to become final and without giving Congress notice. Guys, this happens all the time in government. When they decide we're not going to enforce this thing, and until we get the law changed, we're just not going to enforce it. Obama did this with the Controlled Substances Act in Colorado. He said, you know what? The feds aren't going to get involved there. We have in the past, up until now, we're not going to get involved there anymore. They do it all the time. Temporary modification was an effort to implement the removal immediately without waiting for the rule to become final and without giving Congress notice and an opportunity to exercise its oversight role. Its oversight role. They don't have oversight. They delegated it. The notice is not an opportunity for Congress to change things. Congress will just have to write a law in either case if they want it to be done. They would have to actually write a new law returning the authority to Congress to override the decision. Legislative vetoes are grossly unconstitutional and have been blown out by U.S. courts for probably a century, maybe longer. Congress delegated this authority. Congress doesn't have oversight of this. They get notice of this. Big difference. Because the removal to which the states object occurred as of July 27th, a subsequent notice is obviously not timely under the statute. Footnote, to the extent the federal defendants are relying on 22 CFR 126.2, this is amazing, guys. 22 CFR 126.2 says that they can do exactly what they're doing. Okay? It's a federal regulation. It's not a statute. Regulations are how statutes are implemented. And there's a reason that this regulation exists. It's because in the statute, it also says they can do this. And then this regulation was created. So 22 CFR 126.2 as authority for the temporary modification, which says they can make a temporary modification. Its use of that procedure to immediately redesignate an item that was previously covered by the USML without congressional notice violates the governing statute, except it doesn't. And then he quotes a case in saying, it is beyond dispute that a federal regulation cannot empower the government to do what a federal statute prohibits it from doing. Now later, conveniently removed from this footnote that the judge decided to rule in a preliminary injunction that this federal regulation is unconstitutional, because that's what the judge just did here. He's trying to invalidate a federal regulation on his own devices in a footnote. This is stunning. Stunning what the judge is trying to do here. It's absolutely ridiculous. I can't express it enough. Okay. The statute, he's going to talk about it down away from this footnote, but the statute gives them authority to do this. And the federal regulation is just merely how they implement the statute. He's misciting Tuantai versus Ashcroft. Just blatant bad lawyering on this judge's part. Because he's a liar. He's a liar. He should be impeached and thrown out of office for this. I'm not kidding. Like, that's how serious it's getting. We have judges lying. Flat out lying. Doing work that a first-year law student would find reprehensible. Congress was not... Okay, so, yeah. Concurrence of the Secretary of Defense. So here he's going to basically say that this doesn't matter. When the president delegated his authority under the AECA to the Secretary of State, he also imposed a requirement that any change in designations of defense articles and defense services subject to export control have the concurrence of the Secretary of Defense. There is no indication that the federal government followed the prescribed procedures. You know, I mean, other than they said they did. Plaintiffs are not likely to succeed on the merits of this aspect of its claim, however, because the relevant executive order expressly states that it does not create any right or benefit, substantive or procedural, enforceable at law or in equity, or by any party of the United States against the United States, its department agencies, or entities, its officers, employees, or agents, or any other person. So we want them to do this, but there's no teeth if they don't. Great. Abrogation of state and federal law. In response to the state's objections regarding the scope of the purported authorization for any United States person to access, discuss, use, reproduce, or otherwise benefit from the CAD files at issue, both the federal and private defendants disavow any intent to alter or in any way impact existing federal prohibitions or limitations on the prohibition or possession of firearms, which they can't do through this rule change. Federal defendants also recognize the continuing viability of state law gun control measures. Plaintiffs do not address this argument in their reply memorandum because the plaintiffs in this case are a bunch of disingenuous attorneys general who are lying under oath and should also be impeached and disbarred for stuff like this. Arbitrary and capricious. Guys, misrepresenting arguments to the court, misrepresenting facts, and misrepresenting law to the court is sanctionable activity. And we have a list of attorney generals who have done it. They should be disbarred or at least disciplined. It's ridiculous. Who polices the tyrants, right? Arbitrary and capricious. Plaintiffs allege that the federal defendant's decision to allow defense distributed to upload the internet CAD files containing 3D printing instructions for the manufacture of undetectable weapons was arbitrary and capricious because the State Department failed to consider the factors set forth in the AECA and or to overrule or even address its earlier findings justifying regulation of the files. Federal defendants state that the change was a result of a multi-year review process which led to the determination that firearms up to .50 caliber do not provide the United States with critical military or intelligence advantage and therefore do not warrant continued control under the USML. Even if the court accepts that the undisclosed administrative record will support this argument. And 10, plaintiff's motion to strike arguments based on the administrative record is denied. The plaintiffs said that they wouldn't provide the record, but then they made a motion to dismiss the administrative record arguments. It's baffling. Move to compel production of the administrative record if that's what you need to do. There's no indication that the department considered the unique properties of 3D plastic guns or evaluated the factors Congress deemed relevant when the department decided to authorize the posting of the CAD files on the internet as of July 27, 2018. That's because mentally handicapped people could figure out that they were wrong. Anybody with any cognitive integrity could figure out that they were wrong, that you can't get an undetectable firearm from this. It's not possible because it would be non-functioning if it were undetectable. Until April 2018, the federal government took the position that the technical data related to the design and production of weapons using commercially available 3D printer posed a threat to world peace, and they determined this based on nothing but their own feelings. And the security and foreign policy of the United States, that was arbitrary and capricious and a restriction on rights, and that should have been reviewed, by the way. Some of its concerns related specifically to the undetectable nature of a gun made from plastic. I can't say enough how stupid these people are. Like, they're honestly, willfully stupid. Some of its concerns... Because they were virtually undetectable in metal detectors and other security equipment, literally never. The State Department feared that they could be used in assassination attempts, hijackings, piracy, and terrorist activities. Other concerns related to the portability and ease of manufacturing process that would allow terrorist groups and embargoed nations to evade sanctions, repair weapons, restock arms supplies, and fuel violent regional conflicts. Terrorists. Have you ever seen a terrorist without an AK-47? They don't. It's cheaper than a 3D printer by a long shot. They have stacks and stacks and stacks of them. And fuel violent regional conflicts. Both aspects of the technical data at issue would, the State Department feared, subvert the domestic laws of nations with restrictive firearm controls, even though they haven't, impairing the United States' foreign relation with those nations. Again, made it up. Just made it up. Overall, Department of State concluded that the worldwide publication of computerized instructions for the manufacture of undetectable firearms was a threat to world peace and the national security interests of the United States. Guys, every single piece of these things, like the technical data, is available on Wikipedia. Because, and the U.S. Patent Office. Anybody can access what parts are needed to make these firearms. They're all over the place. The CAD files don't do anything. Anybody with CAD experience and technical drafting and design experience could make the files from all of the existing data that's available everywhere. This is entirely disingenuous. Overall, the Department of State concluded the worldwide publication of computerized instructions for the manufacture of undetectable firearms was a threat to world peace and the national security interests of the United States and would cause serious and long-lasting harm to its foreign policy. Against these findings related to the specific defense articles at issue in this litigation, federal defendants state only that restricting the international availability of firearms up to .50 caliber will not provide the United States with critical military or intelligence advantage. There is no indication that the department evaluated the unique characteristics and qualities of plastic guns. 5 years of litigation, but no indication. Of course they considered it, you idiot, when it was considering the deletion of the small firearms category from the USML. Statements made at oral argument affirmatively suggest that it did not do so prior to July 27th. Nor is there any reasoned explanation for its change in position regarding the harms that publication of the regulated technical data will engender. Don't gender this. To the SJWs watching, this judge is attempting to engender this decision, and how dare he do that? The State Department also appears to have evaluated the export controls on small caliber firearms only through the prism of whether restricting foreign access would provide the United States with a military intelligence advantage. Because that's what they care about under the USML, you idiot! Congress, however, directed the department to consider how the proliferation of technical data and related weaponry would impact world peace, national security, and foreign policy. And they chose to do it through the lens of military or intelligence advantage because they can. Because the case law on this is a mile long. Of course they can do it in the way that they see fit. And the funny thing is, this dummy is right about to cite a different president's manner of doing so in the way he saw fit as evidence for how the Trump regime must act. But that is wrong. It's just wrong, and I don't know how else to say it anymore. When President Obama, you can hear it in his voice, can't you? When President Obama initiated the multi-year review of the export control system on which defendants rely, the stated goals of the review included enhancing U.S. national security, that would be a military and intelligence advantage, and updating the Cold War era system to address the threats we face today and the changing economic and technological landscape, under which they probably determined that since terrorist regimes and other countries have unlimited access to small arms being AK-47s, anything up to .50 caliber, that this data isn't going to help them. Based on the existing record, plaintiffs have raised serious questions regarding the merits of their claim that the federal defendants failed to consider the aspects of the problem which Congress deemed important and then delegated the authority to the executive on how to issue or how to handle that important duty, failed to articulate a reasonable explanation for this particular decision in light of its prior findings and representations, which they don't have to do, and engaged in arbitrary and capricious agency action after 5 years of discussion, litigation, and negotiation. The private defendants argue that this court lacks jurisdiction over plaintiffs' APA claims because the APA does not apply, quote, to the extent that agency action is committed to agency discretion by law. Here we go. The AECA expressly commits one type of decision to agency discretion as a matter of law. This is a lie by the judge right here. The decision to designate an item as a defense article or defense service, 22 USC 2778H. The decision at issue here, however, is the removal of an item from the USML, which Congress chose not to make unreviewable. You liar. You liar. Notice he doesn't quote the statute here. I'm going to pull it up. I'm going to pull it up on my end. I'll read it to you. 2778. Let me get down to H here. H. The designation by the president or by an official to whom the president functions under subsection A have been duly delegated in regulations issued under this section. The regulation that the judge earlier said didn't apply was issued under this section of items as defense articles or defense services for the purposes of this section shall not be subject to judicial review. So the designation of items necessarily includes the non-designation of items. I can't state it. I can't state enough. I can't state enough. The president has the power to determine what goes on the list, but they're going to say that the president doesn't have the same power to determine what goes off the list. That's not true. Okay. Quote, over the years, the Supreme Court has read 701A2 to preclude judicial review of certain categories of administrative decisions that courts traditionally have regarded as committed to agency discretion. Thus, an express legislative bar, such as that found in 2778H, is not a prerequisite to a finding that an action is committed to agency discretion by law. So they don't even need the statute. They don't even need it, but they still have it. Think of what this judge is doing here. The Supreme Court has found that an agency's decision not to initiate enforcement proceedings, not to grant reconsideration of agency action, or how to allocate funds from a lump sum budget allocation are presumptively unreviewable, which is effectively what the agency has done here, because those decisions often involve complicated balancing of factors within the agency's expertise. Congress imposed no relevant requirements or restrictions, and there is no adequate standard by which the judiciary could evaluate the agency action. Those factors do not apply here. What? 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 Why? Plaintiffs are challenging the federal defendant's failure to comply with certain procedures that Congress and the courts have imposed when making removal decisions under the AECA. Not the temporary modification proceedings or procedure, which is what they actually did. Quote, the process by which an agency makes a rule may be reviewed for compliance with applicable procedural requirements regardless of whether the substance of the rule itself is reviewable. There you go. The judge just decided that even though Congress gave the authority to the State Department and said the judiciary can't review this, they just decided that the judiciary can. In this order. They're going to get blown out on this. They're going to lose this because it's settled. It's clear-cut law. Authorization of Congress and the executive. The courts have the weakest position here. And this judge is taking the weakest of weak positions. They don't even have likely authority to review this. And in the event that they do, this judge is wrong. But it doesn't matter because he can say he's right and pose a national restraint on the federal government's delegated authority. It's stunning. It's stunning. And then let's just blow off the First Amendment here, right? Let's just do that. The private defendants argue that the CAD files are protected speech under the First Amendment, that restrictions on their ability to publish the files constitute a prior restraint that is presumed to be unconstitutional. Yes, and that the regulation should be subject to strict scrutiny because all prior restraints on speech are subject to strict scrutiny and are presumptively unconstitutional when the speech is content-based. And this is clearly content-based because not all publications on the internet are treated this way. Only 3D printed CAD files of guns. Not even all CAD files. Hashtag not all CAD files. Whether or not the First Amendment precludes the federal government from regulating the publication of technical data under the authority granted by the AECA is not relevant to the merits of the APA claims plaintiffs assert in this litigation. Yes, it is. Plaintiffs allege that the federal defendants failed to follow prescribed procedures and acted in an arbitrary and capricious manner, which they're applying the wrong way, when they issued the temporary modification of the letter authorizing the immediate publication of the CAD files. The State Department has not attempted to justify its action as compelled by the First Amendment, nor have the private defendants shown that their First Amendment interests are a defense to or otherwise invalidate plaintiffs' claims against the federal defendants. No, they're asking you to do that as a federal judge because you know that this can't survive a First Amendment challenge. Especially when the government says, we don't want to deal with this. To the extent the private defendant's speech is impacted, just being completely and utterly infringed, their First Amendment interests are considered in the balancing of hardships and public interest section below. This is infuriating. Guys, if you wonder why I keep scratching my head, I have a heat allergy. And when I get angry, my body heats up, and I'm literally having an allergic reaction to this judge's stupidity right now. Irreparable harm. Plaintiffs have submitted evidence. Evidence! No. Plaintiffs have submitted statements, made-up feelings, and falsehoods, including declarations and the federal defendants' prior findings, which they no longer stand by. They ignored the existing findings and put so much weight on prior findings, it doesn't make any sense. Showing that the states will likely suffer irreparable injury if the technical data for designing and producing undetectable weapons, which are a fantasy under all current technology, using a commercially available 3D printer. You cannot create an undetectable weapon using a commercially available 3D printer. You cannot do it. It is impossible to create a functional weapon that is functionally undetectable weapon using a 3D printer. You can't do it. You cannot do it right now. Are published on the internet. Many of the same concerns that prompted the DDTC to conclude that the CAD files are defense articles within the scope of the USML apply with equal force to the states. No, none of them do, actually. Not one of them applies to the states. A gun made from plastic is virtually undetectable. Lie. In metal detectors. They have metal in them. And the bullets are metal. And other security equipment intended to promote public safety at airports. No, they're not undetectable by the other security equipment, which is the backscatter imaging and pat-downs. Those two things will find these guns. And so will the X-ray, by the way. You know, I mean, just in case. Or not the X-ray, the metal detector. The metal detector will also find them. You liar. And so will the imaging that they use, because that imaging can see plastic and liquids and everything else. Okay, to promote public safety at airports, sporting events, courthouses, music venues, and government buildings. The portability and ease of a manufacturing process that can be set up virtually anywhere would allow those who are by law prohibited from manufacturing, possessing, and or using guns to more easily evade those limitations. They already can with a CNC machine or with, you know, a drill press. They can already do it. The publication of the technical data would subvert the domestic laws of states with more restrictive firearm controls. Nope. Literally impossible to do so because nothing would change with the legality of the states. And threaten the peace and security of the communities where these guns proliferate. 0 incidents. 0 dishwashers kill more people. Significantly. A shocking amount more people. Infinity more people, technically. In addition, the states have certain public safety, law enforcement, and proprietary interests that were not of particular concern to the United States when considering the effects the technical data would have if exported to other countries. That's because the concerns of the states don't matter in determining if we should export this to other countries or not. The instability and inaccuracy of 3D printed firearms, which are the most dangerous thing on Earth, but apparently they're unstable and inaccurate, pose threats to the citizens of the plaintiff states. So the state's just trying to protect you now, including both users and bystanders. Oh my gosh. Listen to this sentence. While the toy-like appearance increases the risk of unintentional discharge, injury, and or death. Listen to that made-up falsehood. It's complete fiction. Guns that have no identifying information, guns that are undetectable, and guns that thwart the use of the standard forensic techniques to link a particular projectile to a particular weapon. Will hamper law enforcement efforts to prevent and or investigate crime within the state's respective jurisdictions. Here you have a federal judge whose knowledge of forensics exists entirely from, like, NCIS. Do you honestly think this guy has any idea how ballistics units link firearms, like, to bullets? Do you? Do I? No, this federal judge certainly doesn't. He certainly doesn't. If you haven't seen Book of Mormon, you're making things up again, Arnold. And to the extent a state itself utilizes metal detectors in its courthouses, jails, prisons, or public buildings, it will have to expend additional time or money in an effort to maintain security if, as the private defendants advocate, every person owns a plastic gun. Find an ocean and jump in it. The plaintiff states in the District of Columbia, as sovereigns, represent more than 160 million people. No, I don't think they represent 160 million people right now. By the way, I don't think they do at all. Many of whom, and this is a direct lie, have seen the threat level of their daily lives increase year after year. We are safer now than we were when 3D printed guns were created. We're safer now than we were in the 80s, 90s, early to mid 2000s. They've seen their safety increase year over year. The threat level decrease year over year. The District of Columbia, New York, California, Virginia, Maryland, Minnesota, New Jersey, and Pennsylvania have all brackets experienced reduced homicide rates. But let's see what the judge says. Endured assassinations or assassination attempts. School shootings involving students of all ages have occurred in Colorado, Oregon, Washington, Connecticut, Illinois, California, Virginia, Pennsylvania, North Carolina, Massachusetts, Maryland, Iowa, Hawaii, Minnesota, New York, and New Jersey during the past 20 years. Why are we talking about the past 20 years? Shouldn't we only be talking about the last 6? When they actually started making 3D printed guns and publishing the files? And you can't argue that they've experienced more of these events because they're flat. You liar. You liar. You liar. Have experienced workplace shootings. During the same time frame, California, Colorado, Connecticut, Illinois, Minnesota, Hawaii, Massachusetts, Maryland have experienced workplace shootings with multiple victims. None of these are 3D printed gun related, by the way. And of course, hijackers were able to crash airplanes into fields and buildings in Pennsylvania, New York, and the District of Columbia/Virginia in 2001. 9/11, not a single firearm, much less a 3D printed one. Nothing undetectable. They used box cutters, which are made of metal. Not a single relevance here. You're invoking 9/11 like a coward. Hashtag never forget. Plaintiffs have a legitimate fear that adding undetectable and untraceable guns to the arsenal of weaponry already available will likely increase the threat of gun violence they and their people experience. Nope. Zero. Because it's still expensive and cumbersome and ridiculous. Defendants do not argue that any of these injuries are reparable. No, dead people aren't reparable. Rather, defendants argue that the injuries are not causally connected to the State Department's decision to overturn its prior CJA determination to remove the CAD files from the USML. And they're right. The federal defendants assert that because of the AECA regulates the export of defense articles, a change in their regulatory stance cannot be the cause of domestic effects of which plaintiffs complain. And they're right. As discussed in the standing analysis, this argument ignores reality. What? And is wholly unpersuasive. To who? To who? The inclusion of the CAD files on the USML prevented the technical data from being posted on the internet. So, because there is no domestic internet, the ban had the collateral effect of making it more difficult to locate and download instructions from the manufacturer of plastic firearms, both domestically and internationally. No, it didn't. It is because honestly, the average person does not know to go to Defense Distributed to find this thing. They would go to Google and they type in 3D gun CAD file. The same thing you could do for the past 6 years is what the average person is going to do. Whether Defense Distributed posts them or some idiot on Reddit posts them, it doesn't matter. It's the same process for the overwhelming majority of people. Because, Judge, you wouldn't have known either. You probably still don't. Here we go. The ban had the collateral effect of making it more difficult to locate and download instructions for the manufacture of plastic firearms both domestically and internationally. It takes virtually no imagination to perceive the direct connection between removing the CAD files from the USML, the internet publication of the technical data, and the likelihood of the irreparable injuries plaintiffs have identified. But that's not actually at issue. And those irreparable injuries the plaintiffs have identified are hypotheticals that have never happened, and they have no evidence that they will happen. Not a shred of it has been presented. The private defendants, for their part, argue that the causal connection is broken because 9, footnote, in their memorandum and oral argument, the private defendants state that they published 10 CAD files pursuant to the authorizations they received as part of the settlement. File pertaining to the Ghost Gunner 2 assembly files were not covered by the USML and not subject to ITAR control. 9 of the CAD files at issue are already on the internet. Defense Distributed posted them again for good measure on July 27th, as soon as the temporary modification authorizing letter were issued, but took them down when the temporary restraining order was entered. Nevertheless, plaintiffs have shown that they are likely to suffer irreparable harm in the absence of an injunction. No, they haven't shown that. They've just asserted it, and you bought it because you're a freaking idiot. First, it is not clear how available the 9 files are. Very. You dummy. Very. Listen to this sentence. Listen to this judge. Listen to this guy. This guy's like 100 years old. Listen to this. The possibility that a cybernaut with a BitTorrent protocol will be able to find a file in the dark or remote recesses of the internet does not make the posting to Defense Distributed site harmless. Let's see. Google. Google.com. 3D gun CAD file. Download. Here we go. Grabcad.com. Library. Gun. There it is. There it is. There's a whole bunch of CAD files for guns right there. 3D printed gun report. 3D weapon models. How many results on... 866,000 results on Google. Just the 866,000 though. So a cybernaut with a BitTorrent protocol might be able to find the file in the dark or remote recesses of the internet. A Google search. A Google search. And not even an in-depth one. Second, there is no information regarding when these files were posted and whether they were posted with the approval of the relevant government agency. So, absent such approval, the files remain technical data subject to ITAR control because they are not in the public domain for purposes of the AECA. Third, many of the files have not yet been released, including files created by third parties, and any files Defense Distributed will develop in the future. Yeah, they're never going to get out. You idiot. Fourth, the private defendants' dogged pursuit of the right to publish these files because they have a right to do it. And the evident alarm with which the proposed publication has been met in Congress, in the White House, under Obama, amongst advocacy groups, and in state houses all over the country, is irrelevant because this is protected speech, suggests that further publication is not harmless. Finally, the federal defendants argue that the states will not be harmed at all because the United States is committed to enforcing the Undetectable Firearms Act of 1988. While the court... listen to the patronizing garbage this guy spews. While the court appreciates the earnestness with which this commitment was made at oral argument, it is of small comfort to know that once an undetectable firearm has been used to kill a citizen of Delaware, Rhode Island, or Vermont, first of all, 0. Second of all, pretty specific, Judge. What are you planning? Maybe someone should investigate the judge on his plans to kill someone in Delaware, Rhode Island, or Vermont. The federal government will seek to prosecute a weapons charge in federal court while the states pursue a murder conviction in state court, which is how it works. The very purpose for which private defendants seek to release this technical data is to arm every citizen outside the government's traditional control mechanisms of licenses, serial numbers, and registration. Yes, which you can already do on your own. You can make your own firearms all day without the government's involvement. This just makes it more accessible for everybody because more information is better than less. Ask the church. It is the untraceable because you can't sell them. That's what makes them untraceable. An undetectable nature of these firearms that poses a unique danger. 0! Promising to detect the undetectable while at the same time removing a significant regulatory hurdle to the proliferation of these weapons, both domestically and internationally, rings hollow and in no way ameliorates, much less avoids, the harms that are likely to befall the states if an injunction is not issued. Harms that are not contemplated by the federal government's role here. If the state wants to regulate them, the state needs to do so. And good luck. Good luck. Get unelected. Balance of hardships and public interest. 2 pages left. Sorry this is so long, but it's just long. Against the likelihood that the states will suffer the various harms discussed above, the federal defendants... Because there is no likelihood of the harms coming about because of the ITAR stuff. Okay? The likelihood of harm of federal guns having an exercise ball, it's likely that someone's going to die from an exercise ball at some point. It's just the inevitability of tragedy, right? So something will happen. But it's a freaking miracle that in 6 years no one's been killed by a 3D gun. Like, that's a miracle. Against the likelihood that the states will suffer the various harms discussed above, federal defendants identify no hardship of their own, but argue that the public interest in allowing the executive to exercise its discretion. I mean, the hardship is simply that the federal government has authority and it's being restricted by states without the authority to restrict it. The public interest in allowing the executive to exercise its discretion in determining how best to promote national security weighs against preliminary injunctive relief. Absolutely. That discretion must, however, be exercised through the procedures established by Congress, which it was, and not in an arbitrary and capricious manner, which it wasn't. The private defendants raised the more substantive argument that a preliminary injunction will impair their First Amendment rights, a loss which, quote, for even minimal periods of time, unquestionably constitutes irreparable injury. Now the judge goes on with some of the dumbest analysis yet. The First Amendment argument raises a number of challenging issues. Is computer code speech? I don't know. Judge, is a video game speech? Is networking software speech? Absolutely. Of course it's speech. Of course it is, you idiot. If yes, is it protected under the First Amendment? Absolutely. What is it? Is it fighting words? Is it hate speech? Which probably is still protected under the First Amendment. Is it obscenity? No. Then it's protected and you know it is, of course. To answer those questions, one would have to, I don't know, have taken a constitutional law class ever in their life. One would have to determine what the nature of the files at issue is. Here is, are they written and designed to interact solely with a computer in the absence of the intercession of a mind? Or will the recipient, or is it an expressive means for the exchange of information regarding computer programming and or weapons manufacturing? I don't know. Is it computer generated image speech? Because that's what a CAD file actually is. It's computer generated image. Does it interact with the mind? Yes, absolutely. And unquestionably, it does. Let's see. Try and just take a gun design and make your own and commercially market it and see if that gun design that you just make on a CAD file is protected speech or not, and if someone has a copyright interest in it. All right. Or is it an expressive means for the exchange of information regarding computer programming and or weapons manufacturing? Obviously, it's that. Are the export controls of the ITAR a prior restraint, giving rise to a presumption that they are unconstitutional? Yes, absolutely. Is the AECA a general regulatory statute not intended to control the content of speech, but only incidentally limiting its unfettered exercise? Yeah, and it must be weighed under strict scrutiny. Or is the government attempting to regulate distribution of the CAD files because of the message they convey? Obviously! Obviously they are. Obviously. They're not regulating other CAD files. They're not regulating... they're not regulating the U.S. Patent and Trademark Office or anything else. It's obvious that these files specifically and the message that they represent specifically are what's at issue here. Depending on which level of scrutiny applies, strict. It's a prior restraint on content-based speech. It's strict scrutiny. Take a basic con law class, Judge. You know this. Does the regulation advance important governmental interests unrelated to the suppression of free speech? That would be intermediate scrutiny, and this is certainly not intermediate scrutiny. Certainly not. I defy you to find a prior restraint on speech case that uses intermediate scrutiny. Ridiculous. And avoid burdening more speech than necessary? Or is the regulation narrowly tailored to promote a compelling government interest? That's strict scrutiny, and that's what it needs to be. And it fails. It fails under strict scrutiny, obviously. The court declines to wade through these issues based on the limited record before it, you coward, and instead presumes that the private defendants have a First Amendment right to disseminate the CAD files. Well, at least you got that right. But listen, don't stop here. The hits keep coming. That right is currently abridged, but it has not been abrogated. Right. You can't do it, but your right is still there. It's just abridged a little bit. Regulation under the AECA means that the files cannot be uploaded to the internet. Listen to this! But they can be emailed, mailed, securely transmitted, or otherwise published within the United States. How does that not impact the state's interests in the exact way that you just said that publication on the internet would? The court finds that the irreparable burdens of the private defendant's First Amendment rights are dwarfed. Listen to this. First Amendment rights, irreparably burdened, are dwarfed by the fake irreparable harms the states are likely to suffer if the existing restrictions are withdrawn, and that overall the public interest strongly supports maintaining the status quo through the pendency of this litigation. I mean, it's stunning. It's stunningly bad. Stunning how bad this ruling is. For all the foregoing reasons, plaintiff motion for preliminary injunction is granted. The federal defendants and all of their respective officers, agents, and employees are hereby enjoined from implementing or enforcing the temporary modification of Category 1 of the United States Munitions List. In the letter to Cody R. Wilson, defense distributed in the Second Amendment Foundation issued by the Department of State on July 27th, and shall preserve the status quo ex ante as if the modification had not occurred and the letter had not been issued until further order of the court. The court is ordering the government to restrict speech against the will of the government, against the First Amendment rights of a private citizen, for nothing. On made-up authority. Good job, Robert Lasnik. Go to Greenland. Honestly, get out. Get out. Resign. Get impeached. Go away. Unelect yourself from this. And may you die happily of natural causes somewhere where we never hear about you again. You're a disgrace. You're a disgrace to the judiciary. You're a disgrace to your oath of office. Get bent. Get bent, you coward. That's all I got, y'all. This is a disgusting ruling. Hopefully we'll be talking to Cody Wilson soon, and we can go through some of the finer points of this ridiculous order. And until then, you know, keep it up. Keep it up. Keep up the fight. Support Defense Distributed. Even if you don't want to do it with money, support them with your words. Support freedom. I don't have a 3D printer. I'm not going to buy one anytime soon. I got too many kids to afford a 3D printer right now. That would be a cool luxury. I'd love to do it. I really want a Ghost Gunner. I don't have the money to throw at one right now. If I did, I'd gladly do it. But until then, I'll support it with my words. But I'm just saying I don't have an interest in these CAD files being up there for any particular pressing need, other than the fact that speech frickin' matters. The First, Second, and Fifth Amendments actually really matter. They've been abridged and abrogated by this judge far in excess of his authority. They've taken away the actual purpose of the federal government and put it in the hands of little mini tyrants from states that have no authority to do what they're doing. I'm done. I gotta stop. I'll rant about this all day. Still pissed off. You guys have a good night.